Before we even hit play, understand this. When a judge calls it a drop-dead date, that's basically the legal version of don't test me. Every lawyer in this room knows someone's about to get cornered, pressured, or exposed.
We will go on the record in the matters 25 CF43, 25 CF42, State of Wisconsin versus Kenneth Achterling, and State of Wisconsin versus Stephanie Achterling. Appearances are, we do have the state appearing through District Attorney Kevin Schmidt in person. We do have Kenneth Achterling appearing in person with his counsel, Michelle Erdman. We have Stephanie Achterling appearing in person with her counsel, Charlene Perrin. We're set today in this matter for the final pre-trial. This is the court's drop-dead date. We do have a speedy trial currently set for 5 days to begin on December 1st, 2025. We do have to handle and take care of here today. As this is the final pre-trial, I'm pulling up the court's scheduling order in this matter so that we can make sure that we go through everything, because it needed to be, everything needed to be done according to the deadlines provided by the court in the scheduling order. I'm going to start with Ms. Perrin. Can you please provide me an update on whether or not you believe that this matter has reached an agreement or is close to reaching an agreement and you just need a few little moments or other moments to tweak it? Alrighty, so anything else that you can update me with regards to your case, because according to the scheduling order, we do have certain dates that we have to abide by, because again, this is a speedy trial and we need to make sure that we are ready to go.
So I filed our motion, I believe. I filed a letter about our experts with them.
I reviewed that with the DNA expert. Now you're pulling that back. I reviewed your motion in limine. I didn't, in your motion, didn't see anything too different.
Nope. So, no, Your Honor, there's nothing at this point that I think I really need to raise with the board.
Excellent. Thank you, Ms. Perrin. Ms. Erdman, I'm going with you second because you did file your motion in limine as well as your motion objecting to a lay testimony by the CIC. I don't know what that stands for, but that MOCIC employee. And so I have reviewed all of them, and this is the date and time to discuss these matters so that we are all prepared to move to trial. Because again, this is my drop dead date. That means the court will not accept any agreement after this date. That means that if we move forward, either the defendants must plead guilty to all of the counts that are charged against them, or the state must dismiss those counts or some of those counts outright. Otherwise, the matters will proceed forward to a jury at that time, if convicted, or for the trial. And then we will proceed later. So Ms. Erdman, this is your time to make any arguments as to your motion.
Judge, I filed both a motion in limine and then a separate motion addressing, I guess, what could be kind of framed up as lay testimony in introducing cell phone site data. I think that's probably the bulk of what would be addressed, so I'll start there. And essentially, I think there's a couple of concerns. So the way that this case came on was a speedy trial demand that I don't know that anyone, myself included, was expecting. So we've all been working hard to comply with the deadlines. We had a conference and the court gave us a scheduling order. And in that order, I noted that there was particularly something referenced about making sure that Daubert hearings were heard timely. I kind of gave it some time waiting for the state's witness list, anticipating that I wanted to file one, but didn't see the state's witness list forthcoming. At that point, I just wanted to put everyone on notice, hey, I want to make sure that everyone knows this is an issue. And I think the Daubert issue really came down to whether or not the correct person would be seeking to submit the information relative to cell phone, and kind of based technicalities that are involved, things like whether or not the cell phone sites, are on a hill and how that can impact the reception, and the location isn't exact. And there's this concept where a pie chart is typically drawn, which is kind of like a 90-degree angle, and how that really isn't necessarily meant to be interpreted literally, kind of thing. And so I put that Daubert motion out. The state rightfully pointed out I had an error in my motion that had listed I recycled a motion, so the names listed were nonsensical. They weren't applicable here. And I acknowledge that. That was my mistake, and it was just a sloppy mess. And so the motion was out there. The state then responded by email. I don't intend to use a expert. I expect that this will come in under lay testimony and cited a case. And so it was only, I think 2 days ago or yesterday, I can't remember when I was working on it, that I was able to really sit down and digest the issue. So I apologize for the tardiness. But essentially where I've landed, Your Honor, is that it's an unsettled standard in the state of Wisconsin, whether or not expert testimony is required. When it was cited by the state is state versus Cameron. That's 2016 WIS App 54. And that essentially adopted an unpublished opinion, State versus Butler, 2014 App, AP 1769. State versus Cameron was a case fact pattern where there was a stipulation as to the accuracy of the cell site information. So the data from the cell phone provider was already stipulated to, and it was literally a plotting exercise on a map of taking the latitude and longitude coordinates and applying them to a piece of paper. And in that case, the courts held that it doesn't really require any kind of specialized knowledge, and that it doesn't take an expert to make a map using cell phone tower data provided by the hoga. That was the holding in that case that the state was purporting to rely on. And so as I've set forth in my motion, there's a couple of things. One, this is not stipulated to information. And two, the attachment the exhibits that I attached, exhibit 1 is a copy from the provider, it's AT&T in this instance. And there's a couple of cautionary disclaimers at the top. The results provided are their best estimate of the location. Please exercise caution in using these records for investigative purposes. Location data is sourced from various databases, may cause location results to be less than exact, right? So that was kind of the place where we started. And then at the bottom, it disclaims that it's proprietary information. That's so it's using a compilation technology that they're not willing to disclose to the outside public world. And so, Your Honor, we'll see on Exhibit 2 is the data that was put together by the analyst, or I guess I'm not sure of her position there, but the MOIC person out of, I think it's Missouri is where the lab is located. And I just want to, call to attention the purported caption or heading of this: all cell sites for calls, data, SMS messages, and time in advance for this phone number for this time period. That's what the exhibit is purporting to show. And then there's a pin where the quote unquote burglaries occurred. So that's noted in the top corner. And so then if you scroll down, there's a second pin that's been added, and that's the area frequented by subject. And if you kind of look between the two, right, if you start at the top and then look to the bottom, the area frequented by subject is not supported. It's not supported by the cell site data. So that seems to be kind of a hearsay, or that information likely came from an alternate source. And Then as it goes forward, they've applied the familiar high shape kind of notations, etc. And it goes into even, broader strokes that way. So what the state, I believe, is saying now in the response that I saw is, well, I can still do this, right? I'm going to just use the AT&T witnesses.
Speedy trial deadlines are like courtroom landmines. One wrong step and boom, your whole case collapses. And right now, both defense teams are sweating bullets because they're out of time, out of excuses, and almost out of moves.
That weren't disclosed yet because I reviewed the second witness list filing that was made within the last week or so. There's still no one listed from AT&T to introduce business records, such as the cell phone location data. But the state's saying, I can get around this, and my expectation is I would just call these folks, have them say, this is our business data, this is the detail, and then we've simply just done a mapping exercise. That's how the state's asking to introduce this. The business record obviously will be subject to cross-examination, especially as it relates to the disclaimer at the top. But I think I would pose to the court, even if we've got someone sitting here from AT&T who says that we at AT&T pull latitude and longitude data using various sources that we consider proprietary, but they're databases, and we use that to compile this. And then the state is permitted to take on that mapping exercise. At what point in this process do we hear from someone who can say, but wait, this is something that's next level, this compiling of data at the source involves certain levels of expertise, certain levels of, software. Here's how it works, here's how it's explained. And this is why what you're seeing on the map looks the way it is. And I'm sure the state will be very quick to say, but judge, if the defense wants that kind of information to come before the court, then it's the defense's burden to provide that technical detail. I simply want the ability to take what has been deemed less than exact, that's the words that they use, less than exact data from AT&T. I just wanted to take it and put it on the map, judge. And if the state doesn't like, or if the defense doesn't like it, then they should bring in someone to tell me why I can't. And I think that it's something that the court really should be aware. The federal courts have held a variety of different ways on this. It's not settled law in Wisconsin. I did give you the cites in my motion that there were some people that were pretty vocal that this needs to be introduced at an expert level, that's at the federal level. But I will also say, in certain instances, under the correct amount of correct circumstances, where there's already either a stipulation as to the accuracy of the data, or at the lowest level, there's just not a lot of contention, that the courts have been open to allowing people to do kind of, I guess, what amounts to a mapping exercise, right? Take and plot, location A here, location B there. But I guess the confidence of the data to begin with this less than exact disclaimer, and then taking it and applying it as they have on Exhibit 2 and saying this represents all data, all sites, all cell sites for the calls, right? And yes, sometimes calls bounce off of one tower to a second tower to a third tower simply because of the way, Your Honor lives in the Northwest. You understand cell phones are not, precise and exact. They don't necessarily always work in certain areas. There's some areas that are better than others. It has to do with topography, etc. So I think it's something that we just, need the court to be mindful of what's been done in the past. Our urging would be that the court say that this, based on this level of detail, without someone coming in to interpret, it's just not sufficient to be introduced in this matter.
Thank you. Ms. Perrin, I know this is not your argument, but you are a co-defendant, or you represent a co-defendant in this case. And so your opinion on this matter, your statement as it relates to your client is important.
Right. I would join Attorney Erdman in her argument, and I can file motion as well.
You don't need to file a motion as well. I think I will take this as an oral motion to concur and side with the arguments made by Ms. Erdman.
Yes, and she did tell me about it, and we did talk about it the other day. I haven't had time to file anything, but I did review the federal and the state cases. I agree the federal cases do support not allowing the state's witness to testify about this, and I agree that this Wisconsin state law is not settled in this area.
All right, thank you. Mr. Schmidt.
I have two main thoughts on this topic. One, I don't know how the court could accept the arguments by the defendants without just completely eviscerating everything Cameron stands for. When I look at paragraphs 25 and 26 in Cameron, they specifically address this exact argument. This was the argument put forth to the Cameron court. They talked about what the experts said about accuracy and reliance and mapping.
When a defense attorney says no agreement this confidently, it means things are about to get messy. Either the prosecution's deal was terrible, or the defense thinks they can beat the case at trial. Bold move, but bold doesn't always mean smart.
So I think what the court is hearing right here is not an argument that this evidence is inadmissible for some reason, because they are admitting it's layperson testimony. They are not saying this is Daubert. Then this argument is an argument for a jury. It should be, hey jury, the top of this document that Manny Britton used says it's inaccurate somehow. What does that mean? State didn't present that. The weight of this evidence is lesser. This doesn't bear towards credibility, and in fact, Cameron cites positively towards courts accepting cell phones in 2016 without a Daubert hearing or mapping data on it. It's 9 years later. There isn't a single person in this courtroom who doesn't have a cell phone. There isn't a single person anymore who doesn't know how cell phones track location through cell towers to satellites. This is not something that is needed for expert testimony anymore. I think you'd have a better argument saying that juries would need expert testimony to understand a landline more than they'd need to understand a cell phone, just because of how times have changed and the ubiquity of cell phones in human life, and specifically with like the location data. Who has never used Google Maps or something like that? When a person alleges that something requires an expert, what they're actually alleging is that it is something that requires expert testimony. That is, the jury needs an expert to interpret or understand what it is, how it was collected, why it exists, or anything like that. This isn't that kind of data anymore. People understand that the GPS collects your location data. If the defendant brought like an expert or something to testify to that, it would just be an attack of the credibility of evidence. It wouldn't be like, this shouldn't come in because I found an expert who says this is inaccurate and people shouldn't rely on it. And that goes again towards, we should be talking about admissibility, not weight of evidence. Second, and this goes towards like a broader complaint I had about all the motions in limine filed by Mr. Ochterling, is they were filed yesterday. I had minutes to hours to respond to any of these. I'm not forfeiting that I think Cameron is abrogated or overruled or language in it is dicta because of federal cases. I think that the cell phone data comes in as a certified business record. Mandy Britton can map it based on Cameron. And if they want to attack the weight of evidence because there's no one from AT&T to explain how it's collected, that's up to them. What I wrote in there about all of these issues being solvable if I lost a hearing on any of these related to the timeliness of the motion. The defendants, I don't think it's reasonable to play dumb and say, I don't know who they're going to call until they file a witness list. They've had this information for months and months and months. It's referenced in the criminal complaint. It's unreasonable to think I'm just not going to use evidence I've given them or I've referenced in the criminal complaint. And the reality is I'm kind of being thrust into one-day notice motion hearing right now. And if the court rules against me in normal course, what I do is, well, the solution is I just call someone from AT&T and then I still get it in. But the problem with, requesting a speedy trial and then doing the motion in limine the day before the end of the deadline per the scheduling order is I'm kind of just prejudiced and a victim of brinksmanship, really. Like, a speedy trial is not intended to force a shotgun wedding where everyone has to go to a trial where people are unprepared or who've taken reasonable, deliberate actions, which I think the state has done in this case. And the way they know State v. Cameron is I notified them and said, I don't think this is expert testimony. I let them know that in case they did want to challenge it in a timely fashion. So I think the court should find it does come in through State v. Cameron. And yeah, and if we're just addressing this, then I assume we'll move on to the other things. Thank you.
All right, thank you. Brief reply or rebuttal?
Just I guess, I do acknowledge that a day for attorney to prepare is unfair. Like, I'm not trying to push things. If he needs some time to review, but I still maintain that the court, I think, even if I was ineffective in bringing this at the last minute, it's certainly something that warrants review.
Well, I appreciate that. Thank you. And Ms. Erdman, I do not, even though there could be an argument against that, and there is an argument from the state that with regards to timeliness and the scheduling order, et cetera, it's well-versed in case law that courts must be a little bit more lax when it comes to scheduling orders in criminal matters versus civil matters. In civil matters, I can be cutthroat. Nope, you did not follow that to the letter, so absolutely no, even case dismissed, whatnot. But this is a criminal matter, and I have to look more and to put more weight on the defendants and their constitutional rights and the need to be heard. And that's exactly why we are having the hearing today. And I do understand that it puts the state in a little bit of a tight spot to have to argue it here today. But I'm going to tell you, state filed a motion, and as you can see, I review and I read things. And the state was able to make a pretty thorough argument in a brief amount of time. I think after receiving your motions, it was filed within an hour after that or something, bing, bang, boom. So I think the state has had the ability to be prepared, and so this is adequately in front of the court here today. If by chance either side would like to have an argument after the fact, even though this is a final pretrial, the drop dead date, the court will still allow that in writing. However, the court is more lax as it relates to the deadlines in the scheduling order in a criminal case, and that's where I am and that's where I'm going to be. So even though it is past the deadline, it is still ripe to be heard in my review. But however, although I do understand your argument and I do understand, I am denying your motion based on State v. Cameron. I know that it may be undecided or nothing set in law, federal versus state, but State v. Cameron, at least in my court, that is what dictates and that's what rules. And this will be an argument for the jury. And that's where you can present your own witness. I'll even permit the defense to find and locate an expert to testify at the speedy trial, even though my scheduling order states that an expert report must be submitted within 30 days prior to trial. I believe that in a case like this, and having the witness that the state has with the arguments made by defense, if by chance you happen to believe that you find an expert or even another lay witness that can testify, a report can be provided along with the deadline for the witnesses. And in my view, I do understand that there is a holiday, that there is the Thanksgiving holiday there, but in my witnesses and or then any report could be November 21st. Granted, it doesn't give much time for everybody to be prepared, but then I believe it's more fair to the defense to be able to find another witness if you wish, or to be able to then you know as of today what questioning you can line up to question Ms. Britton when she's on the stand to cross-examine her and her knowledge of the mapping as well as the other issues as you see related to that data.
Judge, I just